Hi everyone, Michael Truman here with Munitions Law Group. In today's video, I'm going to be giving an update on the status of several federal gun issues, including a major lawsuit which was pending, which just concluded, restoration law, and ATF regulations, which are going to be getting a fresh look. As you can imagine, it's an exciting time in our industry and specifically in the legal industry. With the Trump administration now in office and fully kind of taking charge and pushing out the old, in with the new. It's led to a lot of interesting developments in the gun law area, and we're really starting to see the impact of that. It was a little bit slow to kind of ramp up, but now I think they're really hitting the ground running and going at full speed in the gun law area. So first off, I want to talk about the Bryan Range case. And if you look back on our channel, I did a full video on this case several months ago, and there's basically an update now, and that is that the case is concluded with a favorable outcome for Mr. Range. And I'm going to talk a little bit more about what that means. But first off, just a quick recap on this. So Bryan Range was an individual. He was convicted of making a false statement in relation to an application for food stamps. So essentially he lied on a food stamp application. And in Pennsylvania, that conviction was a misdemeanor, but it was punishable by up to 5 years of imprisonment. And this is a little bit of a tangent, but a common misnomer is that you only lose your federal gun rights if you're convicted of a felony. It's actually not what the law says. In fact, the word felony is not in the Gun Control Act related to disabilities at all. What the law actually says is that you lose your federal gun rights if you've been convicted of a crime whose maximum punishment was more than a year of imprisonment. So it doesn't matter what the sentence actually was. It just wasn't more than a year. And if it was, it brings with it a federal firearm disability. However, then when you look at 18 U.S.C. 921, which defines the term crime punishable by a term of more than 1 year of imprisonment, it has an exemption, and it says that any misdemeanor conviction that was punishable by 2 years or less of imprisonment does not count. So if it was a misdemeanor, you actually only lose your gun rights if it was punishable by more than 2 years of imprisonment. So in the case of Bryan Range, his misdemeanor conviction was punishable by more than 2 years of imprisonment, so he lost his federal gun rights. And he filed a lawsuit all the way back in 2020, so 5 years ago, that this case took to wind its way through the court system. And he filed a lawsuit, and what he argued was that the federal firearm ban was unconstitutional as applied to him. So he made what's called an as-applied challenge. When you're challenging federal gun laws, you can make a facial challenge or an as-applied challenge or both. A facial challenge is you're saying that the federal firearm ban is unconstitutional as applied to everyone. There's no people that it's constitutional when it's applied to. That's obviously much more difficult and much more of a long shot as opposed to an as-applied challenge when you're basically saying, I'm not challenging the general constitutionality of this law, but I'm challenging it as applied to me. And that's what Range did. He said, I'm an individual that has a single nonviolent misdemeanor conviction. It was over 20 years old. I've had nothing else on my record since then. The federal firearm ban is unconstitutional as applied to me. And initially in the federal district court, which is basically the lowest step in the federal court totem pole, it goes district court, appellate court, Supreme Court. The district court said, Mr. Range, you lose. The federal firearm ban is constitutional as applied to you. The case then got appealed up to the Third Circuit Court of Appeals. That's the appellate court level. And they argued the case, and then while it was pending, the United States Supreme Court issued the Bruen decision, and that's another case that we have a whole video on, but basically the Bruen case, for our purposes today, it was a major Supreme Court case that kind of upended how gun rights cases are looked at in the analytical framework. So the Third Circuit Court of Appeals said, hey, now that we've got this Bruen case, even though we haven't issued a decision, we're going to make you basically resubmit all your briefs, re-argue the case, and then we'll make a new decision. So that all happened, and then the appellate court said, Mr. Range, you lose. The firearm ban is constitutional as applied to you. Range then asked for what's called an en banc review. So not to get too much into the weeds of this, but when you first have your federal appellate case is looked at, it's assigned to a 3-judge panel. So 3 appellate judges are assigned to make the decision on your case. You don't actually get the entire Third Circuit that looks at it. And there are somewhere around 20 to 25 judges usually on an entire circuit. but only 3 are assigned to look at every case. And in very rare instances, after a panel, which is what the 3 district judges are called, the 3 appellate judges are called, they're called a panel. In rare cases, the entire court will agree to look at the case, and that's called an en banc review. So Range asked for the en banc review, where he said, hey, I think that the panel got this wrong. We'd like the entire Third Circuit to look at it, which means every judge would get a chance to weigh in from the Third Circuit Court of Appeals. The en banc court agreed to hear the case, so that was obviously good news for him, and he got to re-argue the entire case before the entire Third Circuit Court of Appeals, and this time he won. They said that the federal firearm ban was unconstitutional as applied to him. The federal government, and this was still under the Biden administration, then asked for what's called a writ of certiari, which means they asked the Supreme Court to weigh in. So when you go from the district court to the appellate court, you have an automatic right to an appeal, but you don't have an automatic right for the Supreme Court to hear the case. You have to ask them to hear the case. If they say that they'll hear it, then you get to argue it and get to a decision. So the Biden administration asked the Supreme Court to weigh in, and that request was pending at the time the Rahami case came out. And this was another recent Supreme Court case, which I actually did another video on this one. And this one came out, and it, again, kind of changed the way that these federal firearm cases are examined. So the Supreme Court said, hey, en banc Third Circuit, we're going to actually vacate your decision, and you need to reissue it under the Rahami case reasoning. And that happened, and the en banc court came back again and said that Mr. Range wins. So then the question became, the Trump administration came in, this case was still out there, it was still within the window where the Attorney General's office could have asked the Supreme Court to take a look at it and reverse the decision. And initially, Pam Bondi asked the Supreme Court for more time to basically extend the time that they had to request Supreme Court review, and that just passed here within the last week or two, and the Attorney General did not ask the Supreme Court to review the case. So what that means is Brian Range's case is finally concluded. It took 5 years to get through the courts, but it is not going to the Supreme Court, and Brian Range's firearm rights are now restored and intact. So the big question then is, what does this mean for everyone else? And the key thing is that Mr. Range made an as-applied challenge. That means this case only directly applies to him. So it doesn't restore anybody's gun rights except for Brian Range, but at the same time, people who have similar case facts to Brian Range, if Brian Range's conviction doesn't take away his gun rights, if that's unconstitutional, then people who are similarly situated to Brian Range could certainly make the exact same argument, but it doesn't directly apply to anyone else. But it's definitely interesting that Pam Bondi decided to not appeal this. In some ways, I think that that's good, that she's not necessarily saying that the appellate court was correct, but she's not going to fight it. But on the other hand, maybe you wanted the Supreme Court to look at it because you think that you would get a favorable decision, which that would then help people all across the country rather than just the Third Circuit. Only the Third Circuit is now the first court to have an en banc court say that an as-applied challenge actually wins. Before the Range case, that had never happened. So that's certainly good news. So that's it on that lawsuit. I want to also touch on the federal restoration process. I sound like a broken record here, but that's something we also recently did a video on. And just to recap, essentially the federal government, again, Attorney General Pam Bondi, announced that they are going to be relaunching the federal restoration process, where anybody who has lost their federal firearm rights can now apply to get them restored through a federal process, which is soon to be launched. As of today is May 5th, that process, they have not published a new regulation outlining how that process is going to work as far as an application form or anything like that. But as of last week, 9 people just had their names published in the Federal Registrar saying that their firearm rights were restored. The one name on that list of 9 that we all know is Mel Gibson. And I'm guessing, I'm going to read these names. If anybody else knows who any of these people are, if they have any kind of connections or celebrity or again, connections to the Trump administration, drop a comment, let us know, because I'm curious, because again, all these people have gotten their gun rights back when the formal application for the general public is not actually opened yet. But I'm just going to read these names: Judy Broach, Danny Preston Conrad, Timothy Lynn Dunham, Mel Gibson, Jessica Lynn Jacobson, Joseph Kletchko, Klechko, Wayne L. Mertz, Charles E. Mooring Jr., Patrick Lynn Morgan, and Ronald Joseph Wilkham. And this is actually an interesting point, is under the law, anyone who has their gun rights restored, the list of names must be published in the Federal Register, and that's why this is all public record. As far as when this application process is going to be open to the general public, we're hearing sometime summer, potentially June, but again, that's very much subject to change, and it's something that we're keeping an eye on literally every single day in our office to start that process for several clients as soon as the application and the actual logistics for how it's going to work are published. So something else to keep your eye on, should be coming very soon. Lastly, other Attorney General actions. So Pam Bondi has done a couple other things. One, she has created a task force to look at Second Amendment issues and essentially work to advocate for the Second Amendment and to look for violations of the Second Amendment under the previous administration. Specifically, she has said two things that they are going to be looking at. One is the pistol brace rule. This is Rule 2021R-08F, and this was the rule that said that any pistol with an arm brace attached to it was an SBR, which therefore required it to be registered under the National Firearms Act. As many of you probably know, that rule has been put on hold by courts. It hasn't been being enforced, but the Attorney General's office has specifically tasked this task force to look at that rule. And my guess is that there's a very good chance that that's going to be repealed. To repeal a federal regulation, it's not as easy as just, saying it's repealed. There is a whole process that you have to go through under the Administrative Procedures Act to repeal a regulation. And my guess is this is the first step on that path. The other rule is it got a little bit less fanfare than the pistol brace rule, but it was Rule 2022R-17. And this was the rule that expanded who had to get an FFL. It expanded what it meant to engage in a business. And essentially it required a lot of people who just maybe kind of sold guns, from their personal collection or, on the side as a hobby. It said that those people would have to get FFLs. And again, my guess is that this task force is going to look at that and say that that rule should be repealed and that process is going to start. And then finally, this isn't part of the task force, but this is something else that has just occurred, and I'm guessing, most likely it was initiated by Pam Bondi, is that the ATF has repealed the FFL Zero Tolerance rule. And this is another area we have a video on, but zero tolerance was a policy that was put in place by the Biden administration just a couple months into the new term in 2021. And it basically listed out several violations that if you had this violation, it would be presumed willful. Didn't matter what your compliance history as an FFL was. Didn't matter how good your audit was. If you had one of these types of violations, the presumed action was going to be revocation of that FFL. And this almost immediately led to a 500% increase in FFL revocations. I very much saw this in my office. I mean, there were so many people I spoke to that were, at risk of losing their FFLs due to, one or a very small number of violations if they happen to be a zero tolerance revocation. Well, that policy has now been completely tossed out. There is no more zero tolerance policy. So if you're an FFL and you're watching this, this is essentially a godsend. It's not to say that you can't lose your FFL, but it, I think, is going to be much, much harder. They're not going to be taking FFLs under this zero tolerance policy any further. So that's it. That's it for today's update. Again, if anybody has any insight on those 9 names that got their rights restored, definitely let us know. Or if you see any other updates on when the federal government might be publishing more guidance on this restoration process, certainly let us know. We'll be